Thanks everybody for coming out. My name's Steve Filano. I'm acting today as the Second Amendment advisor for the Erie County Libertarian Party. We also have the chair of the ECLP here, Dwayne Whitmer. We also have Matt Schieber here, who heads up a new organization called Guerrilla Liberty. And we're here today to call on the county clerk, Michael Kearns, to expeditiously add some new satellite locations for pistol permit processing and also bring in some new employees or maybe some existing employees to supplement the pistol permit office in the wake of yesterday's U.S. Supreme Court ruling regarding an expansion of the Second Amendment and the right to carry arms outside of the home. So if we track how this decision is expected to impact concealed carry in Erie County and really across the state as a whole, it really takes the role of judges out of this, because there won't be any licensing officials to review the whole special cause element of the permits. Under the new decision, that goes away. So really what this is likely to come down to is simply the county clerk's employees running background checks on permit applicants, and if they clear that background check, meaning they don't have a felony conviction, they should be getting a permit right then and there. So really what we're calling on the county clerk to do is be proactive about this, not wait for guidance from the state legislature to go ahead and increase capacity in terms of employees and new locations to process permits. We want it to be forward-thinking. And actually, what would be great is to have him draft something and send that to the legislature, send that to the governor's office and say, hey, I'm the county clerk of one of the largest counties in upstate New York. What I think we should be doing is this. I think we should be adding 20 additional employees to this office. We should be adding satellite locations in every town and village to be able to process these new permit applications expeditiously. If we look at how things are going downstate in New York City, from what I've been seeing yesterday, the website that they have to apply for permits actually crashed yesterday because of the number of people in New York City who are now going to be trying to apply for permits. So really we're just looking for the county clerk to be forward thinking about this, think about expanding capacity to service the increased demand, the increased need for these permits, and just going a step further in terms of what the decision really means, because I had a chance to go through it in detail yesterday. Really what this does is it takes the intermediate scrutiny standard through which courts have been judging Second Amendment cases off the table. There's no more two-pronged test. The court actually is making legislators go beyond what's called strict scrutiny and apply a text, history, tradition approach to any existing or new gun legislation. So basically, if any new gun legislation is going to be passed, the legislators have to make a compelling case and go back in history to the founding era and find laws that are analogous to the ones they hope to pass and show a convincing trend that says that this is what the founders intended. So through that lens, I really see this new decision as sort of the death knell of modern gun control. I don't see how any new substantive gun laws, to include a renewed assault weapons ban, would be able to be passed by the federal government. It's really going to hamstring those efforts. I would also say, as someone who's been in the room when assistant state attorney generals have argued to keep the SAFE Act in place, when myself and others have sued to overturn it, they've relied heavily on intermediate scrutiny, that two-pronged test that the court expressly overturned yesterday. So I'd also say things like the SAFE Act and magazine bans probably are on the chopping block in the near future. Those are probably going to go away. So with that, I'm going to go ahead and turn things over to Dwayne Whitmer. Thanks, Steve.
Thanks, guys, for coming out. If you've watched any Hochul press conference or seen Hochul's Twitter feed, the last couple of weeks she's been big on saying it's the government's job to protect you, the government will protect you, the government's here to protect you, the government will protect you. And I think anyone with a knowledge of history knows that the government cannot protect you. If you've seen the mass shootings inside government-run schools and other shootings at government-run buildings, the government really has no ability to protect you. And then after the shooting in Florida, a federal court reaffirmed that the police don't have a duty to protect you. So unless Kathy Hochul knows something we don't, I think history and courts have affirmed the government has no ability or duty to protect you as a citizen. So we're calling on Kearns to not be a typical government agency where you slow walk this, or you take your time, you wait. We're calling on Mickey Kearns to be proactive and allow the citizens of Erie County to start being able to process these permits to get their right to self-defense sooner than later. I think across the state you're going to see a lot of counties stall, delay, wait for reformation, take their time. We're asking Mickey Kearns to actually do the right thing, step up and be a leader in one of the more populated counties in upstate New York. And so that's really why we're here today. It's slight win for gun owners everywhere. You shouldn't really have to argue in front of the Supreme Court to, fight for your rights, but here we are. Good win, and that's why we're here. And I'll turn it over to Matt Schieber, who's here on behalf of Guerrilla Liberty. Thanks, Matt.
Good morning, everybody. Thanks. Guerrilla Liberty is a new group that I just founded a couple weeks ago. Our goal is to complement what these gentlemen are doing, but on the direct citizen action end of things. So instead of relying on government and policies and intervention, we're taking volunteerism and citizen action back to where it belongs with the people and grassroots. So we focus mostly on homesteading and providing people with the skills that they need to be independent of government in their day-to-day life. And part of maintaining independence and freedom is the Second Amendment, and that's why I'm here supporting these guys today. The Second Amendment, above all, protects us from unjust tyranny. It's not about hunting. It's not about self-sufficiency. It's about safety from not only criminals, but overreach from the government. Officials have to think twice before they pass an unjust law because they know that there's an armed populace that could object to the vote. So that's why I'm here backing these guys. Yesterday, while it wasn't as far as broad-reaching as the 26th concealed state that I would have liked to see, the 26th constitutional state that I would have liked to see, it does help go in the direction of freedom within my lifetime. So thank you, guys.
All right, thanks, Matt. Thanks, Dwayne. And if there are any questions from the media, we'll take those.
Going forward, what I understood, the ruling bans any type of restricted permit, correct?
So
what would happen to someone who right now has a restricted permit? Is that restriction totally gone in your understanding?
So that's a really great question. I think that's a question that's going to have to be answered by the legislature. So what happens now is the Supreme Court decision does go into effect right away. So it gets kicked down to the lower court that decided it and the state legislature. So that's going to be the Second Circuit Court of Appeals, which decided the prior decision that got overruled. And the state legislature, probably in concert with the governor, is going to have to look at this decision and figure out, okay, how do we recraft this concealed carry scheme to comport with what the Supreme Court is saying? So people who have restricted permits, yeah, based on what I read, if they don't have a felony conviction, which if that were the case, they probably don't have a permit anyway, but let's just say for the sake of argument they do, then they wouldn't continue with the permit. But if they don't have a felony conviction, which is the only thing that the prior Supreme Court decisions say would bar somebody from having a permit, then they should be able to get an unrestricted permit, as soon as the new system goes into place.
And it's your understanding that no longer will a judge look at these applications, they'll only be employees of the clerk's office?
Well, again, so that's something that the legislature is going to have to look at, but based on how I've read the decision and how a lot of legal scholars have read this decision, the whole idea of a special reason to carry a concealed pistol is no longer valid. So this whole Mother May I letter that you have to draft to explain to a licensing official, which is always a county judge, more or less, throughout the state, since that requirement's gone, there's no reason for judges to insert themselves into this process. So in my view, the best way to comport with this decision from the Supreme Court yesterday and efficaciously move these permitting applications along is just run background checks right in the county clerk's office. And if that check comes back as no felonies on record, these people should be getting a permit like before they walk out of those doors.
And what do you think do you think Governor Hochul's going to try to craft different language to make it harder to get guns that will comply with this ruling? And if so, is that what you're saying, like would have to go through the legislature? What do you expect the state to do to kind of like fight this ruling or craft new legislation? What do you see happening? Right.
So reading the tea leaves before this decision came down, I know in the state assembly there was a bill that had been drafted to change what's called like specially designated places or off-limit places, which is what this building would be, a government building, right? So the Supreme Court decision leaves open a small window for the state governments to say certain places are off limits to carry. They did hem that in the decision. They did say that, anticipating what New York State was going to do, saying that like the whole island of Manhattan, because it's populous and is generally protected by the NYPD, that doesn't mean it's a protected area where you can't carry. So again, looking at that text, history, tradition approach, whatever the governor and the legislature are going to do on that in terms of expanding specially designated places that are off limits, it's got to comport with some analogous trend of regulations going back to the founding era. I don't see any place in the historical record where they're going to find that. So I think it's going to be really difficult to thread this needle I'm kind of thinking that what's going to happen is the legislature is going to come up with something that frankly violates the decision, and people like us are going to have to litigate that all over again. I mean, if you look at what they did recently on the body armor ban, they really just don't know what they're talking about on that kind of stuff. Yeah. They succeeded in banning soft armor, which really isn't in use anymore. It's mostly hard plates. If you look at the red flag law, the Albany Times-Union came out with a story about a week ago that said the number of applications for red flags from state police are way up, but they're getting dismissed because the state police go into court without legal representation. They try to argue the case. They don't know the procedures for doing that, and the cases all get dismissed. So these are examples of the legislature and the governor passing a law. They think they're doing something. They don't think the 5 steps ahead to how do we actually resource state agents to do this stuff, and it ends up accomplishing nothing. So yeah, they may pass another scheme here. It's probably going to get knocked down. Ultimately, what's going to have to happen in this building is people are going to have to be able to walk into this building or any of the satellite office in the county, apply for a permit, undergo a background check. If they don't pop for a felony conviction, they should be getting that permit right there.
Every time that the governor does stuff like this and it's challenged because it's happened so often, how much is all this going to cost us taxpayers? I mean, every single time they challenge the Constitution and my right to carry and all these other things, they lose, and it costs us millions of dollars in legal fees that we have no say in it. Is there anything we can do?
Well, it could, because the taxpayers obviously fund the legal defense of the state. In terms of how much that actually costs, that's sort of unknowable. I guess you could try to FOIA request that information. It's probably going to be obfuscated. So I don't know, millions, billions, yeah, probably somewhere in that range. But yeah, when this is challenged again, and it probably will be, taxpayers are going to fund the legal defense. I would say that hopefully these cases don't end up having to make it all the way back up to the Supreme Court, because now with this new standard, it's very clear to the lower courts like the Second Circuit, they have to take intermediate scrutiny away from the analysis and look at text history tradition. So hopefully the Second Circuit and the other circuit courts comply.
Steve, are you expecting concealed carry and the pistol permitting process are sort of convoluted together right now? When you apply for your pistol permit, you can check the box for concealed carry. I assume there's a lot of people in Erie County who didn't apply concealed carry when they did their pistol permitting because of that special justification you needed. Is there a separate process to do that? As they just say expand the pistol permitted infrastructure here, and that will take care of it all?
Well, I think expanding the infrastructure is a proactive way to account for the legislature giving new guidance. So again, like this decision got handed down, the legislature has to redo the permitting system to comply with the decision. That's going to be issued, and then here, Michael Kearns is going to have to then very likely deal with a flood of new permits. I'm sure he got a flood of applications yesterday too. So in terms of how the process used to work, you're absolutely right. For all permits, even restricted ones that limit you to a gun in the home and to and from a range or a hunting venue, you still have to justify why you need the permit, no matter what. So under the new system, that should be going away. The whole idea of restricted versus unrestricted should be going away. Because again, this decision didn't just deal with permitting, but carrying arms outside the home. The Supreme Court affirmed that the Second Amendment extends beyond the front door of your house, as decided in Heller in 2008, reaffirmed by the McDonald decision a couple years later. Now here we are, 2022, they're saying it applies outside the home, right? Bearing arms. So really when you apply going forward, it should just be, it's one permit to carry everywhere.
So if I have my pistol permit,
right.
But I don't have my concealed carry, do I right now, under how you understand it, do I right now have to reapply for my pistol permit, or is there a separate form to just apply for my concealed carry?
They may come up with a separate form. I mean, I think that's all to be determined. What I would recommend is, invite all the, either do one of two things. Either run a background check on everybody again. I guess you could do who has a permit to confirm that there's no new felonies on their record. If they don't have a felony, then you should just upgrade their permit to unrestricted. For all those people out there who are wondering what to do, if you want to do something now, you can certainly reapply if you have a restricted permit, meaning it's not a concealed carry permit. You could reapply, which I had to do years ago, to upgrade the permit to unrestricted, and you're going to have to explain to, I don't know if it's going to be Michael Kearns or if it's going to be a licensing judge still until the laws change, why the permit should be upgraded, and you would obviously cite the Supreme Court decision from yesterday. But I think ultimately we're going to have to see what the legislature decides to do in the next couple weeks to really figure out what's the next step.
If my understanding is that this ruling, it falls just short of a constitutional.
That's right.
ruling,
That's right.
Which would say
Yeah.
anybody who has their pistol permit has a right to carry under the Constitution. This is essentially saying you would still have to apply for it.
Yes, you would.
How you read the
Yeah,
ruling.
you
But
would
the
still.
judge couldn't deny you because
Yeah.
you don't have a special reason.
That's correct. Yes, you'd still have to apply for a permit. Again, assuming like that you're not a prohibited person, which under the Heller decision back in 2008, really the main criteria for that is you're not a convicted felon and you haven't been adjudicated mental defective and put away involuntarily in a mental institution. If you don't check those two boxes, you're not a prohibited person under Heller and you get a permit to carry like today is how that's supposed to go. That should be the result of yesterday's decision. What you're referring to when you say constitutional carry, that's more of like a permitless carry system where, again, if you don't have a conviction as a felon, haven't been involuntarily committed, when you go to a gun store, there's no permitting office at all. You go to the gun store, they run the background check, you don't pop for either of those two conditions, here's your gun, sir or ma'am, and you walk out the door today. So you're right, we didn't go to that level with the Supreme Court. We were actually on a case that did advocate for that did not get taken up, that may now get relitigated.
Yeah.
But the decision yesterday is simply, you get a permit, but a lot of the restrictions around proving you have a special need to a judge, that's all gone.
Are they going to be able to add more restrictions? Like, let's say when I go to reapply for mine,
Right.
or I pre-register, are they going to add more restrictions that say I'm going to need a mental health check, that I'm going to need this, I'm going to need that? Cuomo and Hochul have done some really crazy stuff. Are they going to be able to do that? And are we going to be able to challenge it again?
So yeah, you would be able to challenge it under the new decision. There seems to be some confusion that, like, I've read in news reports about what one of the justices, it said Kavanaugh, who talked about allowing states and localities to determine like who can and can't get a weapon and get a permit, and he talked about mental health. I think he's referencing again the 2008 Heller information about if you've been involuntarily committed, then that's going to be a no-go to get a permit and probably get a pistol in any event. In terms of the whole idea of like combing your social media account and making you undergo a mental health background check, again, that goes a step beyond what was decided yesterday, right? So in my view, if the governor and the legislature decide to do that, that's illegal under the new decision.
Would I have a case? Would I have?
Yeah, you'd have to challenge.
Say no.
So you have to have standing. So you'd have to go and apply for a permit and have them deny you. And then if and when you're denied, then you can challenge that in court. That's how that would work. Any other questions, guys? Okay, thanks very much for coming.